When you get charged with a DUI, you've been charged, or I should say arrested by the police, and they send the DUI paperwork, videos, machine records, things like that over to the district attorney's office. So in Sonoma County or other counties, it goes to the DA. And there's someone in each DA's office or a group of people who do what's called a rebooking. And these are typically, more advanced DAs who have been around a while. They evaluate each case to see if they should charge as felony or a misdemeanor. Sometimes you might get arrested for a felony in Sonoma County or other counties in the San Francisco Bay Area. And when the case is evaluated, they might decide, well, the injury is less severe than for a felony, so they might make it a misdemeanor there. Or if it's a non-injury case, maybe they see, a blood test comes back and you didn't do any breath testing at the scene, so they never knew your alcohol level or had any idea, and it comes back well under the limit, and they don't charge being at or over an 08 or impaired driving. So those are ways that it can go away. That's not getting dismissed. That's just not getting charged. Now, once they've charged it, and the DAs who do the rebooking that file the charges, they will typically charge either a felony or a misdemeanor DUI, and there's typically at least two different charges for that. We get what's called a complaint at the arraignment, which is your first court appearance. And there are different ways from that day on that we can try and make your case get to go away, get dismissed, or get charges reduced. It's very difficult to do. If we have a really good defense, every once in a while we can talk a DA's office into dismissing a charge. But I will tell you, once a DA's office in Sonoma County, and that's Santa Rosa is where the courthouse is in Sonoma County, once they've charged the case, a DUI case, they really don't like to dismiss them. And the DAs handling the case, the younger deputy DAs, are under instructions not to dismiss any cases. So we can do things like filing suppression motions to show they didn't have sufficient cause to do an arrest for DUI. We go in front of a judge and have a hearing for that. That's one way to do it. Other ways are just to show that there's just not enough evidence, or there's problems with the evidence. More likely than getting a case fully dismissed, and most times our best is, not every case, but in a lot of cases, getting the charges reduced. Now, Sonoma County is very tough with their DUIs, with their misdemeanor DUIs, and so you've got to usually have a very low blood alcohol level to get a charge reduced, and typically no accident. It's kind of like that in most counties. Some counties, you can have a higher alcohol level and still have a chance of getting it reduced. Alameda and San Francisco are more likely to do that. They'll pick their battles, and they want to see that people are doing rehabilitation and things like that, and they still get a conviction. So they're more likely to reduce a charge with a higher alcohol level. They're just, we can always go to trial to try and get a case dismissed in front of a jury, which is the way to do it. And that's always the client's choice. We don't make that decision. We help guide a client through the whole drunk driving defense process, and then let them make the choice if the best result that we can negotiate is not acceptable. So yes, you can get cases dismissed. You can get charges reduced. And the best chance you have that is by hiring the best drunk driving, the best DUI lawyer that you can find in the county that your DUI happened in, and find someone who's experienced, who knows the law in court with DMV. Find someone who just does DUI defense, or mainly does DUI defense. Anybody can say, yeah, I defend DUI cases, but to really defend them, you need someone who's extremely experienced and focuses on drunk driving defense.